My name is Jonathan Sweet. I'm an attorney in California. I have been an attorney since 1986, and I've taught law school classes since 1994. The largest part of my practice involves construction and real estate, and I work closely with contractors, architects, engineers, owners, and others in construction, in large part to help them prevent claims and avoid risks. Everybody accepts risk as an ordinary problem. One way I've used in trying to determine whether or not somebody is a risk taker is I say, it's 2 o'clock in the morning, you can see to the left for a mile and you can see to the right for a mile, and there are no cars coming, but you still wait until the sign says walk. Even though you accept risk as being a part of construction, it's still important to take into consideration specific areas that you can address in order to avoid taking unnecessary risk. I believe that the first major point you should address is choosing carefully who you work with. This means both who you go into partnership with, and it means who you sign contracts with, and others who are involved in construction projects with you. I believe that one of the major sources of problems on construction projects is becoming involved in a project where somebody goes bankrupt, somebody doesn't perform properly, and that upsets the whole apple cart and the project goes down the tubes. I think the process of construction is so much more interrelated than many other industries that when one minor thing happens, it upsets everything. Doing background research on the people you're going to be working with is incredibly important. Information is available on the internet regarding lawsuits people have been in previously. You should go to a company or individual's website in order to find out some background information about them. If the business is licensed by the state, such as a lawyer, a doctor, a contractor, an engineer, you can get background information on how long they've been licensed, whether disciplinary complaints have been brought against them, and other important information which you would want to know in order to decide whether this is somebody you want to work with. When I speak to people about drafting a contract before they're going into a project, often they ask me whether or not I can draft an ironclad contract or a contract which will prevent all problems. I think the problem is that if you go in with somebody who's dishonest or not trustworthy, the best contract in the world is not going to protect you. The second major point I want to address is how you set up and operate your business. It is important to, if you are set up as a corporation, for example, to segregate how you hold your assets. It is important to keep your personal assets separate from your business assets. The primary reason for this is to make sure that if you have a claim against you resulting from your business activities, you don't want your personal assets available to pay a claim or a judgment. If you set up a corporation under the laws of your state, you need to maintain that corporation properly by maintaining the separateness of that. If you have substantial personal assets which you don't want to be available to satisfy a judgment, you might look into setting up a family trust so that you transfer real property or other assets to that trust or to those people so that that's not available to satisfy a judgment. It may sound obvious, but you don't want to be paying personal obligations out of your corporate bank account, and you need to be doing everything you can to maintain the separateness of your personal assets and your business assets. In a case I had for a client arising from a construction project where the general contractor had failed to pay my subcontractor client and the general contractor went bankrupt, my client had to drive by the guy's business every day and see the Land Rover parked in front. And he said, "Why can't we get the Land Rover?" I said, "Because the Land Rover is a personal asset, it's not owned by the business." And as long as he maintained that separateness, the Land Rover was going to stay his. Consulting a trust professional, a lawyer, somebody who does that kind of thing is very important to make sure that you follow these steps correctly. The next major point, number 4, is to make sure that you select and obtain the proper insurance. Certain types of insurance are mandated by law, such as workers' compensation and unemployment insurance. Others are optional: vehicle insurance, property insurance. One of the major reasons why a corporation which has problems may end up having personal assets exposed is because they have insufficient insurance. Even though it sounds like I'm trying to get you to buy insurance, I think a major point is to make sure that you have coverage which is appropriate to the kinds of risks you're facing and to make sure that you update that insurance on a regular basis. Errors and omissions insurance for professionals is not the same as occurrence insurance for businesses such as contractors, and it's important to understand the differences. You should speak to your insurance agent or your attorney to make sure you understand what kinds of things are covered and what kinds of things are not covered. Number 5, the next major point is to actually read and try and understand the contracts that you sign. Sometimes, even when I, as a lawyer, read a contract, I have to make notes for myself to understand what is trying to be communicated by a particular contract clause. Major clauses in construction contracts, such as indemnity clauses, clauses regarding recovery of attorney's fees, and definition of the scope of work for a contractor are very important to understand before you sign the contract. You may still decide to sign the contract, but it's important to recognize how much risk you're taking by signing a contract which in essence is bad for you versus a contract that is more liberal for you. The next major point, number 6, is for contractors, architects, and engineers, and others who add value to property to recognize that under the law of most states, you have the right to record what's called a mechanics lien against the property. That gives you a specific right against the property and a significant leverage point against the owner if you have to make a claim for payment. The laws regarding mechanics liens are very complex, and the deadlines for meeting those requirements are very short compared to ordinary statutes of limitations. It is important that you get an attorney who understands the lien law process and use that person. The next major point, number 7, is to use the legal system carefully. And by that I mean not pursuing small claims when it's not cost effective, determining what kinds of recovery or what are the chances of recovering in a particular case as opposed to not recovering. It's often when I talk to a client about their unhappiness with another attorney, it is that the attorney was not cost effective in pursuing their claim. That either they spent a lot of money on a small claim or that the cost of pursuing the claim got out of hand and the client wasn't really aware of that. On the other hand, for example, when you receive a contract, it's important to have the attorney review it and not just wait until a problem occurs. The next major point to address, number 9, is to recognize and understand the bankruptcy system. In the United States, we have a bankruptcy system which is based on the notion that if a business or an individual gets into financial trouble, that they're entitled to seek protection from creditors and have their assets used to satisfy creditors and, in essence, receive a discharge or be free to go forward. If you are on a construction contract and one of the parties goes bankrupt, the whole game really changes, and it's important that you consult a bankruptcy lawyer to know what your rights are and what steps you need to take. The next major point, number 10, is to recognize that you don't want to be paying a lot of money now for past mistakes, and to be cost effective and be rational about how you approach claims and problems which come up. A lot of clients I speak to are emotionally caught up in the right and the wrong of a situation, or say that they want justice or they want fairness, and in essence what I have to tell them that the legal system is primarily about money and time, how you choose to spend the time and how you choose to spend the money. To conclude, basically, I think you can avoid substantial amounts of risk in the construction arena by using these pieces of information that I've given you in this presentation. Making sure that you choose the right people to go to work with, that you use the legal system in ways which are cost-effective and beneficial to you, and that you recognize that a large part of what your attorney or other consultant can provide to you is a rational approach to dealing with the problems that have come up in the past. Thank you.